Hi, I'm Neil Milton. I want to talk about income taxes arising from beneficiary designations. So, in particular, from RRSPs and RIFs. These are significant. They can cause a lot of mess if they're not dealt with properly. So, a TFSA, when it's closed, there are no tax obligations. The TFSA either passes to a successor holder, the spouse of the deceased, or is wound up and distributed either to the estate or the beneficiaries. No tax consequences. RIF, RRSP, totally different. They are deemed to have been taxable income in the hands of the deceased on the date of death of the deceased, unless the account rolls over to the spouse of the deceased. So if there's a rollover to the spouse, all good, no big tax hit. If not, for instance, if it's a widow or widower and the beneficiaries are to be their children or one of their children, all of that value will be deemed income in the hands of the deceased on the day of their death. So if you have a $300,000-$400,000 RIF, you will have $300,000-$400,000 of income in the last year of death, which creates a lot of income tax. The real trick and the problem arises from the fact that the RRIF or RRSP may pass directly to a beneficiary. They would get 100% of the money in the account, but the estate would have the tax obligation, which could be as high as 50% of the value of the fund. That's why proper estate planning is so important. That's why it's so valuable not to say, great, one child gets the RIF, the other child gets the rest of the estate, because the child getting the rest of the estate will have to pay the taxes that arise from the one who got the RIF. Really important to get expert advice. Very important issue, often overlooked. I hope that helps. If you have questions or concerns, send us an email. We'll get right back to you.